Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about judicial independence. Cases that should have gone to the Supreme Court of Canada, but didn't. The British Columbia Review Board Commissioner is appointed and paid a particular salary, and that salary is determined on the basis of actions taken by government, which means that any decisions made about the commissioner's salary are reviewable on judicial review. The commissioner filed for judicial review on the basis that his salary did not meet the necessary expectations to protect him from potential influence. This is part of the notion of judicial independence. Judges or decision makers need to be compensated so significantly that they can't be swayed by bribes or by any monetary suggestion that things will go better for them if they decide in a certain way. The commissioner had argued that his salary was insufficient to shield him against judicial independence, and the court had to consider the question of whether or not he, acting as the commissioner of a review board, was entitled to the constitutional principle of judicial independence. They decided that he did not. And this case raises important issues because if judicial independence and appropriate salaries to prevent bias and to prevent bribery don't exist for people who are dealing with administrative tribunals and making administrative decisions, then is delegating those decision-making powers to those individuals exposing our justice system to potential for abuse. If judicial officers or quasi-judicial officers in administrative bodies are not fairly compensated for the work they're doing and not compensated in such a way as to avoid any suggestion of a lack of independence, then isn't there a problem with our justice system? Isn't it wrong to have a justice system whereby people could be bribed or whereby people could be swayed by financial gain? That certainly can't be what we want, especially as we delegate more and more decisions to administrative decision makers. Fair compensation is a very interesting issue in the context of administrative law, and for the Supreme Court of Canada not to have taken the opportunity to hear this case and to deal with the way that constitutional issues of judicial independence are raised in administrative tribunals means that it exposes the public to risk of improper actions by administrative actors because they're not being properly compensated as members of an independent quasi-judicial body. And that's frightening. The Supreme Court of Canada should have taken this opportunity to at least provide some guidelines on this constitutional principle of judicial independence in order to better protect the justice system against abuse. And unfortunately, it's going to take another case and hopefully not a circumstance where something goes awry involving an administrative decision maker before the Supreme Court of Canada has the opportunity to revisit this issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, and share with your friends.